Swear, and your microphone should turn green.
All right. Good morning. Good morning, everyone. It is 9:34. I'm going to call this meeting to order. Welcome to the Board of Zoning Appeals. We thank you all for being here. We're going to get started first with the preamble. Madam Secretary.
Good morning. Thank you. My name is Liz Pook. I'm the Secretary of the Board of Zoning Appeals, and I'm going to read the preamble for you this morning, this Monday, March 10th. In compliance with notification requirements of the city's open meeting law in section 101.021 of the codified ordinances of Cleveland, Ohio, 1976, notice of this meeting has been publicly posted. All boards and commissions under the purview of the City Planning Department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting have the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. Please note that call-in users can unmute by using *6. All meeting activity is being recorded via the WebEx platform. These proceedings are also being live streamed via YouTube for public view. We've provided a link to the meeting for those who wish to speak on a particular case via our website and email. All requests to speak on a particular matter have been considered. We have also received emails from those who have provided written comment on a particular matter. Back to you, Madam Chair.
Thank you, Madam Secretary. You want to call the roll?
Sure. Mr. Madison?
Present.
Ms. Roca?
Present.
Ms. Faith?
Present.
Ms. Holzer will be absent this morning.
Okay.
And Ms. Wilson.
Present.
Madam Chair, we have a quorum with 4 members. We should let the appellants know that at this time, with 4 members, they run the risk of a tied vote. And in the case of a tied vote, the decision is denied. Therefore, at this time, if the appellant would like to postpone to a future date when we would have 5 members, they may do so at this time.
Okay. Anybody would like to postpone on that basis? All right. Not hearing anything in the room. Anybody online wish to postpone? All right. Looks like we'll move forward with all matters. Any postponements that you are aware of, Madam Secretary?
No postponements or withdrawals.
Okay, very good. We will move on now to calling the first case. And the first case I have is 25-022. This is at 1974 West 52nd Street. Do we have an appellant for this? Okay, come forward. And while you do that, we will go ahead and read in the case. Whenever you're ready, Madam Secretary.
Calendar number 25-22 at 1974 West 52nd Street. Suzanne Marquardt proposes to build a new 18 by 24 one-story wood frame garage in a B1 two-family residential district. The owner appeals for relief from the strict application of the following sections of the Cleveland Codified Ordinances as stated in the agenda and in the public record.
Okay, thank you. We'll now turn to swearing in of the appellants. Ms. Roca, you want to handle that?
Sure. I'm swearing in all who are present for this case. Do you swear or affirm to tell the truth and nothing but the truth? Please raise your hand, state I do, state your name, spell your name, and give your address. Go ahead, ma'am.
I do. Suzanne Marquardt, SUZANNE, MARQUART, 799 Gettys Bluff, Northfield, Ohio, 44067.
Thank you. Sir?
My name's Bill Wood.
Sorry, excuse me, can you please turn your mics on? Bring them a little bit closer.
Sorry.
Thank you.
Bill Wood with New Creation Builders.
Bill Wood, W-O-O-D.
WOOD, right? Yep.
Name again? Hold on one second. Your name?
Bill Wood. And then our address is 818 East 73rd Street in Cleveland. And was that all you needed?
I do. I think you said I do.
I did, yeah.
Is there anyone on the call for this case? I don't see anyone, Madam Chair. Back to you.
All right, thank you so much, Ms. Roca. We'll now turn to history of the property, please, Madam Secretary.
Thank you, Madam Chair. There's been no change in the zoning since 1929. In our Records Administration Office, we found that in 1925, a permit was issued to erect a shed addition. 1904, a kitchen addition. In 1939, a permit was issued to convert to a two-family dwelling. And then in the more recent history, we see that there were permits for HVAC, electrical, plumbing, all in 2023. And that's all that I have that's relevant. Thank you.
Okay. Hold on one second, not at this time. I'm going to turn now to legal standard, please.
Madam Chair, members of the board, appellant is requesting an area variance from the minimum distance to a main building on an adjacent lot requirement of the zoning code. To obtain the area variance, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code.
Okay, thank you so much for that. Now I will turn to the both of you. Do you want to start first?
I just wanted to make a comment. That's a new house that she was showing there. So when I bought the lot in 2023, there was no house there. I believe there had been a house built there in 1885. So a lot of the permits that she was talking about were for, a previous structure.
Okay.
So that's a brand new house that we built and was finished last August of 2024. And what we're doing now on a 30-foot wide lot is requesting to build a garage.
Okay. And why don't you talk to us about why you need the variances and what difficulty you'll face if you don't
Right
get a
now,
variance?
if you could go back to the other picture there, the house on the left. Oh, that's okay. Well, just, you can see how the house next door, the neighbor's house was, it looks like it was built on numerous different times to continue back into the back side of the property. See on the left-hand side there, how it kept going on and on there? So that's where I think we're running into a problem where we need the variance. Because they're only 6 inches off of the property line on that neighbor's house. And then we're requesting to build a garage of 18 by 24. But we will do a 3-foot variance on our side of the lot where the other garage is only 3 feet. I'm sorry, 6 inches. The existing garage on the neighbor's property.
I just wanted to make one more comment. That house in that view, it's the southernmost or the lowest part of that view. That tail end is actually a garage. It's not, I'm building next to their garage. So
Okay,
they just kind of like kept adding on to that structure over time, but that back end is not their main home. It's actually a garage.
understood. All right, any questions from the board?
You guys see where that is? Is that okay? Or do you want me to show you or?
Yes, I can see
Okay,
where
where the
their
3 feet
garage
mark
is.
is?
You're
in
3
red?
feet from the
Mhm.
property line and 6 feet from the garage, other garage. Is that correct?
I'm sorry, say that again?
Did you say you're 3 feet from your property line, but 6 feet from the other garage? No. that's-
No, it'll be a total of 3 feet, 6 inches because, to that other structure.
Okay.
They are only 6 inches off of the property line where it should have been 3 feet.
I see.
Maybe they're a foot, but they're not 3 feet out.
Okay,
If
And-
if I shift up, then I'm gonna be up against that other garage.
that was gonna be my next question. If you just shift your
If
garage.
we moved it over a few feet, it's gonna be up against the other
Yeah,
one.
I've only got
Okay.
30 feet to
Yeah,
work with.
okay. So
And
either way
both
it
of
goes,
those
it's a little tight.
garages, if you can tell, are really, really close to my property line, which is
Mhm.
kind of has me trapped.
Mm-hmm. All right, any other questions from the board? All right, Mr. Bay, any opinion on this?
Good morning. This is Xavier Bay representing city planning. It is understandable that this is a very slim lot. It's only, like I mentioned, about 30 feet wide. City planning would actually, recommend that the garage be shifted to the I guess, north of the plan here, to minimize variances and increase that distance to the neighboring attached garage. I will just mention that when a garage is attached to a main structure, it's considered, the entire thing is considered as a main structure, which is why you're written up for variances here, because of the distance from your proposed garage to the adjoining home. And so, yeah, I mean, I think in our point of view, it would be better to shift this to the north because you're allowing more room for maintenance on the sides of the garages.
Okay, and how many feet or, what distance do you recommend in shifting?
Yeah, I mean, in our, looking at the site plan here, 6 feet north, would leave you 3 feet next to the adjoining garage there, and ample room or you're increasing you're decreasing your variances because you're increasing your distance to the main structure on the adjoining lot.
Okay, and then from a practical perspective, what's your response to shifting the garage north?
Yeah,
6
it would
feet.
be very difficult to maneuver that. So, already, moving it down. So if you drive down that driveway, it's a very thin driveway. It's only
So let's talk about that. Where does the car come into the garage
the
here?
driveway on the south side. So, the lot the lot to the south of my house is what you're seeing. That's the structure on the bottom. So my property is what is in the middle of that view. The darkest portion there on kind of the upper right, that's the actual house, and you see the porch out to the front. That shaded color that kind of wraps the house, that is cement. That's cement that's already
Right where
poured.
that pointer is, right there.
So that's the driveway that
yep.
comes along the porch and right up the property line.
Okay.
Okay, so the idea was that you're front loading into that, you're just gonna drive right down into that garage. Shifting it up makes it all the more difficult to maneuver that space. It's already really, really very difficult to maneuver. And beyond that, from before I ever started this project, I spoke to 2 different city planners because my city planner changed. So I still have an email from Nathaniel Lowe, kind of indicating to me that this portion of the section doesn't actually, it doesn't actually apply to an interior lot.
The
I
portion of
think
which section?
Of the code, this section 353 of the code.
Okay.
I question that that it's even being applied accurately. And based on what I was given from Nathaniel and, can't remember the gentleman's name, but whoever was his predecessor in that role, had both told me that only, a section that says, detached garages are permitted, provided they're in the rear half of the lot.
Shannon, are you able to opine? I think I saw her on here. Oh, yep.
Good morning, Madam Chair, Shannon Leonard, Chief Zoning Administrator. 353, the variance request is for the distance, correct?
I'm sorry?
Which section is she referring to?
They're
353.05 and
height. Right.
This is Xavier Bay. I just put it on the screen, Shannon. This is section 353.05. It's the height section.
Yeah. And my height.
well, it also addresses distance.
Correct.
No. I think what they're saying is if I only had, let's say I had a 10-foot distance from the main building, then it's saying that the height can only be 10 feet. So I think they're trying to apply a height restriction to distance. The distance is actually, based on everything that I've been able to gather, covered under 337.23 section A2, because it says
Hold on one second. I want to give Shannon an opportunity to respond. There's been a statement that this section 353.05 does not apply to this variance request. And so I would love to hear from you as to your opinion on that.
So this section does apply to regardless of what lot you're on, interior or otherwise. So the variance request is needed.
Okay, that's my reading of it too. So thank you for confirming that.
But can I ask a question? Is it about height or is it about distance? Because my reading of that is saying that that the height of the structure shall be regulated based on the distance from other structures. So this application is not about distance, it's about height.
Well, it's about distance because it's making a requirement that there be a certain distance. And it's requiring that you have 12 feet, and it looks like you're proposing less than 12 feet.
Excuse me, this is Xavier Bay. That if I could just help the clarification, that this section is kind of speaking to both the height and the distance. So,
Yep.
the regulation allows you to go up to 15 feet in height, and that's when you actually have that much room to another main structure on an adjoining lot. And so, basically, you can't go up to 15 because your distance to the home on the adjoining lot is less than 15. So you could only you're supposed to be the same height of your proposed structure. It's supposed to be the same height from the structure on an adjoining lot.
Any other questions from the board? All right, I will entertain a motion.
Well, Madam Chair, I do have a question. So
Yeah.
I don't think we've fully, so your response to the city's request to move it north is that you can't.
So I'd like to have at least a little bit of grass and a little bit of yard. But if you take this and apply it, then no matter what, I'm landlocked. No matter what, my garage couldn't be more than like 6 feet tall or something, maybe even less.
Oh,
Yeah, because this is a height restriction. So what this is saying is that an accessory building shall not exceed 15 feet in height or the distance from the accessory building to the main building on an adjoining premises.
Whichever is less.
So
Right.
if I'm 6 feet from an adjoining building or 4 feet from an adjoining building, then the height of my structure can only be 4 feet. On that particular lot, no matter how I move that garage, north or south, I'd be very limited in height. If you apply this correctly.
Your mic's not on, but I don't know that.
Still need
Yeah, I don't think I
variance.
followed
A
that
variance will still be-
interpretation.
yeah, you still need a
Yeah.
variance. Okay.
So the question is, in terms of moving the garage 6 feet, is that something that is practical or feasible for this project?
and you're talking about moving it 6 feet
North, right?
north, which would be up from here, right? Correct. Right,
Closer to the structure, to the house. That's north?
No, it would be closer to that other
To the
garage.
I'm
other
sorry,
property
I made a
line.
mistake.
It'd be closer to that other garage, but remember, we're driving in on the south side of my lot. We're not driving in on the north side of my lot.
Yeah,
And
so
that
that
would-
might make it a little
It
tough.
makes it very maneuverability, for a truck. It would make it extremely difficult.
Mhm.
So Madam Chair, the other option would be to push it back further.
So that it's not even
the
near
left.
the other building and the variance wouldn't be needed in that case.
would you be opposed to
Seems
moving
that
it back?
The concern, not to speak for Xavier, is that the maintenance of the building of the neighbor's house is
Both
going to be
garages,
limited.
actually.
Yeah,
Yeah.
will be limited with
It's
the small
really
space
close.
between the two buildings.
Mhm.
So we need to maximize that.
There's like 33 feet back there. Am I reading that right?
Yeah.
So for example, if you need to maintain your garage, you have to go on your neighbor's property to do that.
Well,
Just
there's a
because it's
little
so
fence
close.
there. There's actually a fence.
So how would you
Right on
maintain the side of your garage? If
Well,
you
I
need to
have 3 feet.
and that's enough room for you to get,
Yeah, he already has a fence right up against his garage. That's already there. I didn't put that there, you know. But
So
I
what's the
have
response to
reasons.
shifting it back so that it doesn't abut the neighbor's garage?
It's just more expensive project because now I also have to extend the concrete.
Okay. All right, any other questions from the board based on that?
Madam Chair, my comment would be that she's got 27 feet of uh, auto court, basically to maneuver her car. If the garage is moved north by 6 feet, that would make it extremely difficult to maneuver a vehicle in and out of that garage. The other option that you had under discussion to move it further to the rear of the yard could be another option. But again, that would mean more concrete for her, and it doesn't really mitigate the ability of being able to maneuver the car. So a 3 feet side yard is something that we have done previously for other projects. Though the adjoining structure has not been 6 inches off the property line in most cases. So that's my comment at this point. I think we're either going to cause her financial hardship or hardship in being able to maneuver her vehicle if we move the garage from its proposed site.
Okay, am I hearing that you have a motion, Ms. Fay?
I would motion to approve as is.
All right, is there a second?
Second, Madison.
Okay, can we call the vote, please? Rhoda?
Yes.
Mr. Madison?
Yes.
Ms. Bates?
Yes.
Wilson?
Yes.
Calendar number 25-22 is granted. It'll be ratified next Monday. We'll send you a letter that you can contact us next Wednesday for further instruction.
All right, good.
Thank you so much.
Thank you very much, everybody.
Thank you, Ms. Fay.
You're welcome. Good luck to you.
Thank you so much. I appreciate it.
All right, we're now moving to calendar number 25-023. This is at 1344 West 74th Street. Is there an appellant present for this matter? All right, perfect. We'll go ahead and read in the case.
Andrew Conrad, owner, proposes to erect a first floor addition and second floor bedroom addition and dormer attached to existing single-family residence in a B1 two-family residential district. The owner appeals for relief from the strict application of the sections of the Cleveland Codified Ordinances that are stated in the agenda and in the public record. Thank you.
All right, Ms. Rocca, can you do the swearing in, please?
Yes. Do you swear to tell the truth and nothing but the truth? Please raise your hand, state I do, state your name, spell your name, and give your address, please.
Andrew Conrad, I do. That's AndrewConrad. I live at 19850 Indian Hollow Road. That's Grafton, Ohio.
Thank you. Is there anyone who would like to speak in this matter on the call? Seeing any hands raised, back to you, Madam Chair.
Thank you. I'll now turn to history of the property, please.
Thank you, Madam Chair. There's been no change in the zoning since 1929. We didn't find very much in our records administration office. We did see in the more recent history that in 2023, a lead safe certificate was applied for and is stated as inactive at this time. And rental registration was issued to the property in 2015 and 2022. And that's all that I have that's relevant. Also, there are no variances. Sorry. Thank you.
Can I have legal, please?
Madam Chair, members of the board, appellant is requesting area variances from the parking, required rear yard, interior side yard, minimum distance from a dwelling on an adjacent lot, minimum width of interior side yard, and maximum gross floor area requirements of the zoning code. To obtain the area variances, appellant must prove that denying the request will create practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variances will not be contrary to the purpose and intent of the zoning code.
All right, thank you so much for that. I will now turn to you. You want to tell us a little bit about your project?
Yeah. Yeah, so I bought this house and I'm just looking to move into it myself, actually. I hired an architect to kind of draw up some plans here for me. And, I know there's a lot of kind of issues, but I kind of wanted to, I guess, walk through them. The first one here states that there is no parking space. There is like a like a slab of concrete that is used as the parking lot, like the parking space, I guess. We had originally discussed putting in like a car bay, but that I think would have created more problems. So I'm not sure if maybe it's just not listed on this properly, but there is a parking space. Let me see what. So that should kind of knock out the. Oh, so then the second one is that the
Hold
parking
on,
space.
hold on, before we
Yeah, yeah,
move
sorry.
on. So it sounds like the application states, and this will be a question for Ms. Leonard or Mr. Bay, if you can chime in, but it sounds like he does have a proposed parking space. Is there any reason there is a variance when there is a parking space proposed?
Yeah, I mean, from what the applicant's stating, it sounds like that might not be a variance that they need today. It's one dwelling unit. They're providing one parking space. I believe this may even be in a TOD zone, which removes parking minimums.
Okay, so then it sounds like we're gonna take number one, the variance request number one off of the table. Go ahead and give us a discussion about
Um,
number two.
Yeah, so number two was that no parking spaces should be allocated within 10 feet of any wall. So this is actually, you have to go up a few steps to get into the house. So where the parking is, it doesn't detriment from any windows or anything. I can still see directly out of my first floor of the house. I don't know if maybe it doesn't quite look like that on that, but
Madam Chair, if I may.
Hold on, Miss Faith. We have Miss Leonard
Yeah.
ready to chime in. Go ahead, Miss Leonard,
Great,
please.
great.
Variance number 2 is why variance number 1 is on there. So you can't park your car between two residences when within that 10 feet if there's habitable windows on that first floor.
Okay, so given we don't need variance number one, is it safe to say we also don't need number two?
No, I believe he needs number 2 based on the location and him suggesting that he can't pull the car between past the two homes.
Okay, what's your response to that?
I can't, I'm sorry, I didn't hear that catch. I can't pull it past what?
The two homes.
So you can't have parking where there is a driveway between two homes. You're not supposed to park within 10 feet of any home that has first story windows. That's for just in case you leave your car running and somebody has their windows open. Now they're consuming exhaust from the vehicle.
Mm-hmm. So your parking is not in between the homes though, right? I mean, this box that we're looking at that's shaded, is that where your parking designation is?
Correct. No, no, I'm sorry. That is just backyard. I'd be parking where it says existing drive.
In front of
Okay, got
two
it. So
windows.
then that is problematic. Is there another place for you to park?
No. But that's what they've used. Is that just that lot?
Does that go all the way back past?
No, it truly stops right there where that line is where,
Yeah.
Is that because there's a little porch or something? What is that?
there's like a piece of the slab of concrete, but it's not, I wouldn't call it a porch or anything. There's I guess a back door that you can step out onto, but it's in the new plan that will not be there, but.
So is there any reason that your plan cannot create parking away from the homes?
I mean, I could potentially like extend it, yes, to go back, I guess, but I don't know. I think I'd have to see the drawings again, but I think there's going to be a window back there as
There
well
too?
that
Oof.
this would.
Yeah.
Yeah.
I have two follow-up questions. One, is there parking on the street
There is not.
Okay,
So I'd have
and
to go
then
down.
second question is for Miss Leonard. Is he in a TOD? Does this Xavier mentioned that, and I'm not sure if that applies here.
I'm unsure if he's in a TOD. If you give me a few minutes, I can check for you.
Okay.
Okay, no
This,
problem.
this is Xavier Bay. I'm looking at the zoning map now. I can confirm this property is within the TOD zone.
Okay. Does that address your question, Ms. Roca?
So he is in the TOD zone. So can you please explain how that modifies this request?
So if he's within the TOD zone, he is not required a parking space per unit. However, if he's showing parking on his or drive on his plans when it was examined, he does have to abide by the zoning code. So I believe in the plans, it's showing that drive and his only option of parking is to park between two homes. So he would need the variance or he would have to not be able to park there.
Okay, thank you, Ms. Leonard, for clarifying that. Does that conclude your questions, Ms. Roca?
No, is
Okay.
your intention to park a car in this driveway?
Yes.
Okay. So we're back to square one.
We are. He needs the variance. Ms. Faith, did you want to chime in? I know that you had questions before Ms. Leonard did.
Right. Well, I was just going to point out on the plan that the drive was alongside the house in between the two houses. And then Shannon came on. So
Okay,
we've had this situation before where in some cases there's just been a parking pad at the front of the house. And so and we denied those just as a frame of reference. So in this particular case, I'm not even sure he has the lot depth to take the driveway. If he were to go to extend it all the way to the rear of the lot, to give enough distance to park at the rear of the lot. I'm just, because the lot is, it looks to me, is it 73.33? Is that right, Xavier?
I think so.
On the
Correct.
long side.
In terms of the length,
60
yes.
And 62. Do we have a dimension from the rear of the house to the rear of the yard?
I don't know that we do.
This is Xavier Bay. I believe there's a, a dimension here stating 22 feet, 7 inches.
Yeah, there we go.
From this rear line to the back of the home.
All right. Have to extend that driveway all the way to the rear of the lot and park only at the very rear of the lot is, as I'm looking at this, to give him clear distance from the structures. Because parking in between the buildings isn't gonna fly,
So the
in
building,
my opinion.
okay, thank you, Ms. Faith. So I'm looking here and it looks like the building that is adjacent is a garage.
Correct.
It is.
Okay, and where is the home that garage belongs to?
It's like further down in this like corner here, like right in there.
Okay, so you're not necessarily parking next to their home, you're parking
Correct.
next to their garage. Is that what I'm understanding?
Yes.
Very tight though.
It's very tight.
Extremely tight.
Yeah.
I can show you a picture of it.
Do we have a dimension from that existing garage to the driveway?
And then here are his
That might
windows
help us.
right there that are causing an issue.
This is Xavier Big, and I don't see a dimension on the plan from the garage to the drive, just from the garage to the home, being 10 feet.
Okay.
I believe it's like right on the property line, if not, maybe a few inches, because the cement of my driveway is here and the garage is here. It's maybe a couple inches.
Okay,
And Madam Chair, I'd like to follow up on Ms. Faith's line of questioning. So would you be open to, or would it be feasible to extend your driveway
I mean,
back?
yes, I could extend it back, but I guess my question was, with the addition, there's going to be a window back there as well. So I guess I would still be between houses, I guess.
Is it going to be the same line as the current, your two windows? It's going to be in the same spot?
would you mind showing the other, there's another picture that kind of shows what it would look like.
The elevation.
It was like the second or third. Yeah, this one.
It is in the same spot.
Yeah.
And
Uh,
that window is for,
So that would be like a spare bedroom / laundry room. I haven't quite decided what I'm gonna do with it yet, but I mean, if I got rid of that window, would that be acceptable, I guess? Because that'd be an easy change to make.
I think it would be
Okay.
acceptable and it would alleviate all of these issues
Yeah,
you're having with
okay.
the tight space that you have.
Yeah, that'd be
Um,
no problem.
is there another place you could put a window?
Yes, along the back or on the other.
Okay,
other
all right,
side.
that's what I would suggest.
Okay. Actually, there are two existing. You can see in the bottom.
Although
picture
Ms.
there.
Leonard has her hand up, so she might contradict what I'm.
Yeah, I was wondering if that
Right.
was from earlier. Ms. Leonard, do you have another comment or is that an old hand raise?
It's an old hand raise, but if he were
Okay.
to remove that window and replace it, he'll need to submit new plans to be reviewed. Again, to make sure he's not violating any other aspects of the zoning code.
Yes, makes sense. Okay. So then that gives us a plan for number 2. Can you talk to us about number 3?
Yes, so this is one where, so it says it needs to be 22 feet. I believe it's already breaking that code. Like as existing. I'm making it a little bit shorter, but I believe I'm already at 18 foot. And I'm going down less. So, you know, the plan right now is like the back of the house where as it exists, there's nothing above it. So my plan was just to put, you know, a second room above it, but to make room for that, I have to go back a little bit to be able to add a second bedroom above the existing house. And that's why we kind of went back a little bit. You know, the lot is just so small as is that there's not much, I'd not be able to build enough, I guess, a large enough bedroom if I did like stick with the existing, to make it worthwhile, I guess, is kind of my issue.
Mm-hmm.
And since I'm already kind of in violation of the code, I thought maybe I bothered into that.
Okay. All right, talk to us about number 4.
Number 4, yeah, so this one is another one that I don't think I'm technically breaking because it's already less than 3 feet. I'm going straight back. I'm not making it any wider. So I don't believe I'm in violation of that, I guess. I'm going back off of the existing, that back frame there. I'm just continuing that. So I'm not going any wider, so I'm not sure. I wasn't sure about this one.
All right, any thoughts from Ms. Leonard or Mr. Bay?
Yeah, so the side yards are required even if you're following the existing layout of the home. So it's just because he's adding on to it, he still needs the variance request. The home is already non-conforming.
Understood. Okay, so we have a non-conforming home here. All right, talk to us about number 5, please.
Yeah, so this is the last one. This is the one that, again, this is a really small lot and it's a really small house. I'm just trying to add a little bit on to make it livable. The front of the house as it exists is considered a bedroom. And I mean, it's a closet. And to be able to build another bedroom, I would have to go above like what I'm allotted. As is, it's just really hard. I mean, it would be a single person house if I left as is. And so I'm really just trying to add a building to kind of make it a little more modern. I did do a little research and looked at other houses in the area. I feel like I'm kind of in a similar boat to a lot of them. So I don't feel like I'm doing anything crazy that isn't already existing, I guess, in the area. I don't know if I took some screenshots if you wanted, I don't know, but, oh, I'm sorry. So there's other kind of houses like in my neighborhood that I kind of looked at their backyard and kind of the existing house that they have. And it looked like I wouldn't be sticking out, I guess, was my thought process.
Okay, so just to point out, the legal requirement is that you have to prove that denying your request will create practical difficulty that's not shared by other buildings in your area,
Okay.
right? So you have to tell us why your property is unique and why it has to have these variances as a result of that. So I just want to make sure we don't
yeah.
muddy the waters with,
Okay,
with
yeah,
that part
no,
of
that's
it.
fair.
But I think
Um,
you've done a great job of articulating the difficulty in terms of the size of the yard and the placement of the buildings. Do you have anything else to add?
No, I don't think so.
No? Okay. Any additional questions from the board? Pass it to Liz.
Madam Chair, if I may chime in, just with city planning's recommendation, this is Xavier Bay again, representing city planning. This is a very tight lot, so any type of additions, would more than likely have to come before you because of the non-conforming status of the lot and the home. We recommended approval for these additions. There's not really much that an applicant can do to kind of, minimize a lot of these variances. And so that's all we have.
Okay, thank you so much for that, Mr. Bay. If there are no questions from the board, I will entertain a motion, please.
Madam Chair, I move that we approve calendar number 25-023 with the condition that the appellant remove the window on the driveway facing side. I'm sorry, I don't know the
That's good. That was good.
driveway facing side of the structure, and extend the existing driveway as discussed in this hearing and resubmit plans to city planning to determine if any other variances are needed.
Okay. Is there a second?
I'll second that.
All right, thank you, Ms. Faith. Can we call the roll?
Ms. Vey?
Yes.
Ms. Roca?
Yes.
Ms. Wilson?
Yes.
Calendar number 25-23 is granted conditionally. We'll hold ratification until we get that revised drawing. Once we get it, we will ratify it that following Monday and we'll send you a letter.
Is there a timeline on that? I just want to make sure that my architect has time to fix these as far as resubmitting the.
It's your timeline,
Okay.
right?
Right.
I just wasn't sure if there's anything on my end. Okay.
Yeah, so.
I mean, I'm going to be pushing him, but
Yeah.
Yes.
I just want to make sure.
Yeah, no,
Okay.
we'll hold it
Okay.
ratified
Until
for
it's
a while.
submitted.
6 months, I think generally is the length that we try it.
Yeah, it shouldn't take that long.
Good.
Great.
Awesome.
All
Thank
right,
you.
good luck with your
Thank
project.
you.
Very good. All right, we're now going to call calendar number 25-003. This is at 12600 Craven Avenue. Do we have an appellant present for this matter? Yes, okay. While you come forward, we'll go ahead and read in the case.
Cleophas Stephanie,
Yeah.
owner, proposes to establish use as a residential facility for 5 occupants in an A1 single-family residential district. The owner appeals for relief from the strict application of the sections of the Cleveland Codified Ordinances identified in the agenda and in the public record.
All right, and with that, we'll hand it over to Ms. Roca for the oath.
I'm swearing all who are present for this case. Do you swear or affirm to tell the whole truth and nothing but the truth? Please raise your hand, state I do, state your name, spell your name, and provide your address.
I do. Cleophas Stephanie. CLEOPHUS STEPHENEY. 12600 Craven Avenue. That's Cleveland, Ohio 44105.
Thank you. Is there anyone on the call who would like to speak in this matter? Not seeing any hands raised, so back to you, Madam Chair.
All right, thank you. Can we have the history of the property, please, Madam Secretary?
Thank you, Madam Chair. There's been no change in the zoning since 1929. In our Records Administration Office, we found that a permit was issued in 1940 to erect a dwelling and a garage. There are no variances on file. And then in the more recent history, in 2020, a violation notice was issued to the property for unauthorized use. A complaint was made regarding property being used as a sober home. That's all that I have. Thank you.
Okay, and is there anything in the record to show that that was corrected?
Just that no, in fact, I do not see a building permit issued after that, until this one was made.
Okay, thank you for that clarification.
Thank you.
Legal, please.
Madam Chair, members of the board, appellant is requesting a use variance and an area variance from the minimum distance requirements of the zoning code. To obtain the use variance, appellant must prove that denying the request will result in an unnecessary hardship particular to the property, such that there will be no economically feasible use of the property without the variance, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code. To obtain the area variance, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting the variance will not be contrary to the purpose and intent of the zoning code.
All right, thank you so much for that. I'll turn to you now. Tell us about your project, please.
Okay. I was hearing her say something earlier about the use of group home, and it was about the Oasis. And to my understanding, we had got all the proper paperwork done to have it. I was leasing my house to Oasis for back in 2020, and I thought we had all the paperwork done, but I was here because I don't understand all the language she just gave me. But I come because I was trying to see what I need to do to be able to open it back up to a non-profit group home. Is that possible? That's what you know. I had got a letter saying that at some point it was within 1,000 feet of another group home around the corner. And so I thought it was over with. And I came down here. They told me, well, you just need to appeal it. That's how I got here today. So I don't even know where to start at.
Okay, well, this is part of the process to make sure that it comes to into compliance. So what we're going to do is make a decision today regarding whether you have the authority to operate your property as a residential facility. So tell us a little bit about your facility and how you plan to operate it.
Actually, it's a non-profit. This is Hope for You. Name of the non-profit. It's a 5-bedroom, and I was getting somebody to organize, help me get organized with the non-profit because I'm not that, involved in all the details. What I did do was went to Blotts, then about a year ago, went to Blotts and took up some classes with Ms. Dr. Jacob for the certificates and things. And I just took up a lot of classes to learn how to operate with it, but I don't see myself fitting in as an actual operation. I'm gonna have to get somebody to run it as a nonprofit,
Do you have someone to run it at this time?
Yeah, I wanted to make sure, I got somebody to run it. At church, they wanted to do something for women transition, bringing women in, transition them in from off the streets and out of jail and transition them in. So they got all the details on that.
Okay, Ms. Roca, you were gonna.
Are you just the landlord and you?
I am the landlord.
I see. So you own the property, but you would be bringing in another nonprofit
Right,
to do the residential facility.
right.
So typically we hear from the entity who we running the residential facility because we would like to know the hours of operation, how many residents, how many rooms and all that.
Okay.
So are you prepared to testify to that today, or do you need this other entity? Do you have those details?
What would I need to, I'm gonna probably testify to what part of it, I don't know exactly. How they run it, I mean, if I need to get them here, I can set up something to get them if they make it more clear. I can get them here. My main thing was coming to find out whether I was gonna be able to even get started, so I didn't think that I was gonna need them. If I had known, I'd have had them with me.
Mm-hmm.
So,
Are you able to tell us about the details of how they're gonna operate this facility?
well, can I try to get somebody on the phone?
I mean, if they can join the call, sure.
Oh, let me see if I can get one of them.
Okay, we'll give you a moment and we'll recall the case. We're gonna move on to the next case while you do that.
I give them a call outside.
Yeah.
Mhm. All right, we'll recall the case. All right, so we're gonna move on to calendar number 24-215. This is at 672 East 126th Street. Do we have an appellant present for this? There's no one in the room, so is there anyone online prepared to testify in this matter?
Yes, Madam Chair, Councilman Anthony Harrison, City Clerk, Ward 10.
Okay, thank you, Councilman. Is there an appellant online for this matter? We don't have an appellant. All right, can staff contact the appellant and see if they are going to appear?
I believe this
Speaking
is
of
the
staff,
second
and she magically
time.
appears. Oh, wait, hold on a second. It says
Yes,
we dismissed this already because there was an unexplained absence. And
yes.
now we're here again. I certainly can entertain a motion at this point. It is now 10:24, call time was 9:30.
I move that we dismiss.
All right, is there a second?
I move that we dismiss calendar number 24-215.
Thank you for that
I'll
clarification.
second that. Sorry, I was trying to get off mute.
Thank you, Ms. Faith. Can we call the vote?
Ms. Faith?
Yes.
Ms. Rosa?
Yes.
Ms. Wilson.
Yes.
Calendar number 24-215 is dismissed.
Somebody want to help Brittany?
Okay, thank you. That will be our last matter for this today. Sorry, we didn't mean to send you in circles. But, absence twice is a bit much. I'm gonna now turn to some old.
And Councilman Hairston.
Oh, yes, Mr. Harrison, we're gonna go on and dismiss this case since there's no appellant present.
Thank you, Madam Chair, members of the board. Thank you so much. That's what I was
Absolutely.
coming here. I was opposed anyway. Thank you.
Okay, all right. Well, have a good day, Councilman.
You too. Bye-bye.
All right, if there's anyone else online who was present for that matter, you're free to log off. We're gonna now move on to old business. I have numbers 2 through 6. Is there any objection on any of these?
No objection.
No objection.
All right. All of those are approved without objection. Liz, I see a lot going on at the bottom. You want to talk us through that?
So the affirmation that you see is there for calendar numbers 21-184 and 21-185 at 2312 West Fifth Street. This is regarding erecting 2 single-family homes on 1 lot. This is unusual. We don't usually have this many affirmation requests, but the appellant had some legal issues with the neighbor. And the neighbor was constructing a new house of his own. So the appellant was waiting for those 2 things to work out. And I believe at this time that has happened and he's ready I believe the permits are, at least for the rear house, is ready to go and according to the appellant, he said he's ready to start building on the back
I
house.
see the appellant on the call.
Yeah. So, and because he was concerned, I think the last one that we had, the board kind of made the comment that that one should have been the last
Ah.
one. But he's here just in case you had questions.
I just want to confirm with our rules that that we are able to grant this many.
Yet another.
Yes, there are no limits in our rules.
Okay, all right. Well, given that, is there any objection from any board member as far as this affirmation goes?
No objection, but the appellant has now come off mute and maybe, I guess I would like to hear that they can confirm that the issues have been resolved and that they will be able to proceed.
Okay, should we go ahead and swear him in before we take testimony, or is that, okay?
To the appellant in BZA 21-184 and 21-185, do you swear or affirm that the testimony you'll give today is the truth and nothing but the truth? Please state your name and say I do.
Andrew Gottlieb, and I do, yes.
And sir, go ahead with your statement.
Hold on 1 second. Andrew, can you spell your name for the court reporter, please?
Yes, I can. It's Gottlieb.
Perfect. Thank you so much.
No problem. Thank you very much for having me today. Yes, so to reiterate what Ms. Kluko was saying is we had we bought this property a few years ago and went through an approval process that was pretty intense. We had a neighbor who was fighting us every which way. I don't know if the board record can show this, but at one point the neighbor was fighting us on these variances and even hired the attorney Tony Coyne to fight us. We were granted the variances, so we're very thankful. However, he is a very litigious neighbor with some deep pockets in Tremont, and he has threatened us many times that he would sue us. So we wanted to tread very lightly in this process, and as well as be respectful to him. He wanted to build a house. He wanted us to. The original argument in this case was that he wanted an easement granted for free from us in order to get the variances or the neighborhood to support those variances. And so what we did was we didn't give him the easement. He fought us on the variances, and rightfully so, we were approved. So with that, he was going to construct a home in the rear, which he did over the last couple years, and now I believe it is complete. And he had his space. Now we have our space, the tight lot. And now we are actually, we're working with plans examiner Rodney Wells. We're on the last adjudication letter for the rear house. We will pull permit on the rear house, but we will have to renew the variances on the front house. And the reason for that is we cannot build the front house until the rear house is complete because of the size of the lot of what was granted. I just wanted to throw that out there and make sure you guys had a whole complete picture of the step-by-step approach as we've been patiently waiting to start this project. So thank you.
Okay, thank you so much for that additional context. Any questions from the board based on that testimony?
No, Madam
I,
Chair.
d- I distinctly remember this case, Madam Chair, and I have no objection to an extension.
Okay, very good. So we will go ahead and approve that extension, given there are no objections. We don't need to call a vote, do we, Madam Secretary? No? Okay. All right, thank you so much for being here to give your side of the story.
Thank you. I hope you guys have a wonderful day.
Thank you. Same to you.
Bye-bye.
All right, so let's now talk about the request for hearing, Madam Secretary, or rehearing.
Thank you. This is also an unusual request. You may remember this case. Mr. Siegelman was denied by this board in October. He requested you to overturn the decision of a hearing officer in a mowing case.
I do remember
he-
this.
He then appealed to the Court of Common Pleas. He filed timely. And in the meantime, he requested around the same time that he filed to the Court of Common Pleas, he requested a rehearing. The board denied the rehearing because it was not in our jurisdiction anymore. And then the court decided that, and I don't really understand the full language of the court's decision, but it mentioned the word nullity. And so his argument is, since the court dismissed the case as being null, that he should have a second consideration of a request for rehearing that he placed during the time, around the time that he appealed to the court. If you remember, he did submit an affidavit. He believed that there was some new information that he thought was enough to bring it back to the board for a rehearing. So at this time, I think that you have a couple of choices. You can leave it as a denied, and that it was, the board has already denied his original request for rehearing. You could deny it again with the new information, saying you considered the language that the court has included in their decision, or we could bring it back to the table. But again, I think his email's in here if you'd like me to read it. So, and again, in your packet, it's his affidavit regarding the request for rehearing. He believes that since the court has determined that the appeal is something that that never occurred, he is requesting the board to reconsider the rehearing, since the board denied the rehearing based on it being out of our jurisdiction.
So the standard for granting a rehearing is that there are some circumstances that are different that we should reconsider.
Right.
So has he articulated any circumstances that are now different other than the appeal? Substantial facts that we did not hear the first time around that we should consider?
And so that is on page 1, 2, 4, request for rehearing. His number one fact is that during the original board hearing, although requested by the appellant at the hearing, no evidence was presented by the representative for the Department of Park Maintenance and Properties to show that the lawn was mowed. There were no documents, no photographs, and no witnesses to show that the lawn at issue was mowed. These will be requested during the discovery for the rehearing. Number 2, the second fact he's stating is that the lot next door, owned by the state of Ohio, is fenced in on all 3 sides, with the open side near my driveway. Protests of 3 or 4 invoices were granted, although appellee refused to answer why, upon inquiry, it is likely that the appellant or the parcel next door was mowed. The appellee refused to answer why one was singled out for denial and refused to give any evidence. These will be requested during discovery for the rehearing. Number 3, BZA turned off the microphone during the original hearing when he said that he wanted to present evidence that the appellee was incorrect with respect to the current law regarding this matter. Just before turning off the microphone, the BZA said that Chapter 209 was controlling. This is in line with appellee CCO ordinance number 209.01A1 or I, recognizing that grass over 8 inches, is a nuisance. And ordinance number 209.02 states the Commissioner of the Environment may simply publish in a newspaper of general circulating, advising owners to vacate land and requirements of the Chapter 209 states that 30 days after this notice is published in a newspaper, and all of that information was posted in the at the hearing. And B, however, Ohio state law, since it is specific and disagrees with local law, will preempt law 505.87B2, clearly states that the administrative board shall send notice to a non-resident owner by certified mail. This permits an owner time to rectify the nuisance himself. Appellee did not send effective notice to appellant. Appellant will prove this through discovery. Conclusion, it is possible, if not likely, that for the protest not granted, his lawn was not mowed through the appellee. And 5, even if the law was mowed through the appellee, notice was not given to the appellant as required by law.
Okay, so it looks like the lower or the Cuyahoga County Common Pleas Court has denied this appeal because he tried to represent himself through an LLC, which he can't do. And then after hearing the request for rehearing, I still don't hear any changed circumstances. I hear the same argument is being maintained that he doesn't agree with the city for, mowing his lawn, or even if they did mow his lawn, he doesn't agree with that. So I just don't hear anything that would raise to a level of, needing a rehearing. Any comments or questions from other board members on this?
Madam Chair, I would concur. What I was waiting to hear was that he had found proof that he had in fact taken care of the issue, which was the point when we heard the case initially.
Agreed.
Yeah, and hearing that he has not found proof, and he came before us initially without proof, and that all the other citations had been negotiated and taken care of, with the exception of this one, I see no reason to go through this again.
Okay, thank you, Ms. Faith.
Madam Chair, I agree. I do not see any new facts that appellant has articulated that would warrant rehearing. From my reading of his documentation, he is asserting he disagrees with the opinion or the conclusion, but does not have any new facts.
Okay, so do we need to call a vote, take a motion? How do we want to
I think we
adjudicate
should
this?
call a vote.
Okay, I'll entertain a motion on the request for rehearing.
Madam Chair, I move that we deny the request for rehearing.
All right, is there a second?
Madison, second.
Okay, and we'll call the vote on that.
Ms. Roca?
Yes.
Mr. Madison?
Yes.
Ms. Faith?
Yes.
Ms. Wilker?
Yes.
Thank you very much. Request for rehearing is denied. We will
All
send
right.
the appellant the letter.
Perfect. Now we're gonna recall calendar number 25-003 at 12600 Craven Avenue. Were you able to get in touch with the operators of your group home?
Yes, I got a hold of them.
Okay, are they able to attend?
Yes.
Okay, did they log on or?
Now, I don't know, how do I get them logged on?
Hello, this is Xavier Bay. I have a call-in number or a link that we can email them. One moment.
And Dr. Austin, they're gonna need to give you a link, for me to link into to join the thing, ready for.
We are off the record. Yes, thank you.
Okay, she on her looking at us.
Number 2. You call the number, it'll give you the prompt to enter the codes.
Okay, so what? Okay, the other, what is the other password? So, me,
This hearing, yeah, the email I can totally do it.
C, D-I dot Watson, W-A-T-S-O-N, dot L, A as in apple, F as in down, T as in Tom, E as in everybody, and R as in rainbow. D-I dot Watson, dot Lamson, at hotmail.com.
Excuse me, Madam Chair. There are a couple of messages coming through the chat from what looks like neighbors. Whenever you want to hear those, if you want to hear them now, let me know, or if you want to hear them after they're.
We can do that while we
Okay.
wait for the
Yep. So,
other speaker.
okay.
Yeah, I did recall it before we went off. I can recall it and then we can swear in the neighbors and then we can take their testimonies. So we're back on the record. We're gonna call calendar 25-003 or recall calendar 25-003. And we have neighbors online who would like to give their opinion on this. If you are a neighbor, please raise your hand so that we can swear you in, and I will turn to Ms. Roca to do that.
Thank you, Madam Chair. I'm swearing in all who are present for this case. Do you swear or affirm that the testimony you are about to give is the whole truth and nothing but the truth? Please raise your hand, reply with I do, state your name, spell your name, and provide your address. If you would like to speak, please raise your hand and come off mute.
This is Xavier Bay. Specifically, Carolyn Turner. We have received your messages, and if you're having issues with your microphone, I can read these into the record.
Ms. Turner, are you able to hear us and come off mute? Not working, she says.
If you allow me, Madam Chair, I can read these in.
Mr. Bay, please go ahead.
So it looks like starting at 10:19, Carolyn Turner started sending a couple of messages through. Her first message says, "We don't need that activity." Her second message states, "We don't need that. We remember when different we're coming in and out. We have seniors living around," and then she states, "Please decline this request."
Please, what this request?
Decline this request.
Okay.
I do have an email from her as well. If you'd like me to
Okay.
read that.
Madam Secretary, go ahead and let's read that.
She would like to state that she objects to the owner using the property for other than a single family. Their section of Craven has been a nice, quiet, and modest street for as long as she's lived there, which is over 30 years. What Mr. Stephanie is wanting to obtain would disrupt our way of living and affect the stability of this section of Craven. We have neighbors who have lived here for years, a lot of seniors who feel safe and continue to stay due to the lack of disturbances. What Mr. Stephanie is asking would be unwanted activity, which could add to unwanted drama. Please do not grant relief to the appeal he is requesting. And this is Carolyn Turner at 12519 Craven Avenue. I have another email, one from Kim Scott. This was sent also to the appellant. At this time, city planning will not recommend support, and this was on February 6th. At this time, city planning will not recommend support for the project. There are many aspects of the project that are not in place for a successful residential facility. Additionally, we've received comments from residents that objected to the previous use as a sober living house. And she just states that that he can feel free to contact her, and that's Kim Scott, city planner.
Okay.
There's another one from Theodore and Robin Cloud on Craven Avenue. Writing to express opposition to the facility. As a resident of almost 25 years, our street has 17 houses between East 124th and 27th. We are like family. We look out for one another. Out of 17, 14 of us are retired citizens. The reason why I'm in opposition is simple. Mr. Stephanie tried this before without telling anyone. His house was a sober home. On day one, when they moved in, we had to call police because of drunken unruly behavior of the residents. The following week, sheriff's department came looking for a person that's address was never notified, at that address, and they were never notified about anything. Concern is that we don't know who may move into the house right next to him as small children and we have grandchildren that visit often. He's asking that you please vote no. And that's Theodore and Robin Cloud. Thank you. That's all that I have.
Okay. Do we have any other neighbors online or was it just the one?
Madam Chair, those are the only comments I saw in the chat. I can't speak whether to the rest of the people here for this case or not.
Okay. Sounds like we don't hear anything. Do we have the other speaker present that he sent the link to?
Madam Chair, I did not see any new participants in the WebEx meeting online. I just sent another email just in case something went awry.
Okay. All right. Well, we have waited a significant amount of time to, hope that we would get a little bit more of a cooked up presentation. But it looks like we don't have that. Do you know where your speaker is, whether they're going to join us or what's going on there? If she doesn't join us, we can go ahead and move to a vote based on what we've already heard.
I didn't know that it was that many issues and that the neighborhood thought about this home like that. I like to withdraw everything. I don't want to upset nobody
Okay.
for a group home. I'm not that guy. I didn't know there was that many negative things going on, comments.
Okay.
That kind of that's here there, but that's her right there. But I'm
Oh,
just
there
gonna-
You're just going to withdraw? I
Yeah,
mean,
I
we're
think
not
I'm
going to
gonna
take testimony if you're going to
withdraw.
withdraw. Okay. You would want to withdraw?
I think it's better.
Okay, all right, we will honor that request and we'll go ahead and have you withdraw the case. We will not take any additional testimony today. So if things change, you can just resubmit your application and make sure that you have your operators present if you decide to come back. It would also be a good idea to talk with your neighbors about what it is that you're doing so
Right.
that they are aware and that they are, on board with your request. You would also want to talk to your neighborhood planner, which is Kim Scott. You would reach out to her and make sure that you have a conversation with her about your plans as well. Okay?
All right.
All right. Well, good luck to you. That is all for today.
Okay, I appreciate you.
All right. No
Thank
problem.
you.
All right. That concludes our matters. We've already done our old business. So we are adjourned for the day. I should let you know. I'm so sorry, Ms. Watson. It looks like he's decided to withdraw the application. So we're no longer going to take testimony today. But thank you so much for coming. All right. We are now officially adjourned at 10:52. Have a good day, everyone.